All right, good afternoon to you and you're welcome to the program. Apologies for the late start, but this is Good Afternoon Ghana, and we have come your way with more analysis on what's going on in Asing North constituency, and also, of course, the lead is what exactly is happening in the courts. All right, so there's been a lot of updates. This afternoon, we'll be doing this with Alexander Segbefia, who is a member of the NDC legal team. He's a lawyer, a former minister as well. Also, Theophilus Donko is with us. He's a private legal practitioner. He's joined us in the studio. Nano Bribwahin is a former secretary of the deputy secretary of the NPP and also a lawyer as well. He will also join us here. On the discussion. Let me introduce Theophilus Donko. You're welcome, Theophilus. Thank you for your time and good afternoon to you. All right, we will take a quick break and just in a few seconds we'll come back and then I start off with Theophilus. All right, you're welcome back into the studio. It's Good Afternoon, Ghana. Like I said, it's been a legal battle in court where James GYAKYE QUAYSON is expected to be appearing in court day to day, and his lawyers have been trying to plead, but there was also another update from the court today. But before we get there, let me welcome Theophilus once again. You're welcome. Good afternoon to you. So Theophilus is a private legal practitioner. Nana Bribwahin, who's also a member of the NPP legal team, who will join us, and lawyer Alexander Segbefia will also join us later on in the discussion. But some updates from the court's correspondent, Elvis Ankara, actually told us earlier on that there was a bit of some maybe exchange of words with the AG actually throwing some tantrums in court. The judge was also warning against some insults in the courts, and the court struck out the supplementary application to discontinue the case on the day-to-day basis. And so, well, the NDC is expected to be doing this day-to-day. We're told that Chachi Chikata, who is one of the lawyers, was also pleading that the case will not be heard on the 27th of June 2023, the day on which the election, that's a by-election in Asing North, will take place. In all this, let me just ask you your summary, what you think or what you make of it to start with.
Thank you for the opportunity. But before I start, I want to lay certain fundamental principles that governs criminal practice that makes the day-to-day appearance an issue as compared to civil cases. If GYAKYE QUAYSON was facing a civil case, he could have absent himself and asked somebody to represent him. But the Constitution says that when you are facing criminal trial, you should be in court in person the day the court has chosen and the place. So that is the basic reason why GYAKYE QUAYSON and the legal team are fighting the day-to-day basis. And then there is also...
But being in court day-to-day and being in court in person are two different things. He's not fighting being in court in person. He's fighting the day-to-day appearance.
The Constitution requires that once you are facing a criminal charge, you should be in court in person. Unless you conduct yourself in such a way that the judge had come to a conclusion that your presence in court will interrupt or will not allow the smooth administration of justice or will not allow the continuous trial. In that case, the judge can make that determination that your presence is not required. The second one, too, is that if you know that there's a court case in which you are an accused person, and then you absent yourself for a very long time, the court can come to that determination, or the prosecution can make a determination that since you are aware and you are not prepared to stand trial, then they should try you in absentia. In these two circumstances, your presence are not required. And then when it comes to adjournment, it says that when the accused person is on bail, then the judge will have within 1 month to adjourn. But if he's not on bail and he's in custody, then 14 days, 2 weeks. So these are the basis for which differentiate between criminal and civil cases. You have not heard that, okay, a criminal case has been adjourned indefinitely. it is not allowed for a judge to adjourn a criminal case indefinitely. But in civil cases, they happen. A judge can adjourn a civil case for more than 1 month, which is allowed. But in criminal case, under normal circumstances per law, you cannot adjourn more than 1 month if the person is on bail, and no more than 2 weeks if the person is not granted bail. So these are the fundamental differences between a trial being conducted in a civil case and in a criminal matter. And we all understand that this is a parliamentary candidate, and there are instances where we have even been crying that the case has delayed. So if the judge is prepared to hear the case on a daily basis, GYAKYE QUAYSON would have been a happy person, because the Constitution also says that if you are an accused person, you should be tried within a reasonable time. But what has happened over the years is that if you go to other jurisdictions, you realize that when they are trying persons that will follow the broadcast, you realize that it is day to day. But our practice...
Like a high-profile
yes,
case.
because they broadcast it, but that is what is done in the UK, US, even in South Africa. They will tell you that this case we are going to try within this period. But in our case, it is not like that. You go to court, and even when it is trial, you are given only 1 hour, most of the time. So you see a lawyer's diary. Today I've done about 5 cases, but I'm here. Because we go 1 hour, 1 hour, 1 hour. Some you don't even do 1 hour. You just take a date. But in this special circumstance, this is a person who is standing an election. So I think that there are instances that we have given reasons why we cannot even be in court, and judges have accommodated it. So I think that it is the fact that GYAKYE QUAYSON is standing in election next week. That is what has brought all these things. Otherwise, he would have been a happy person to make sure that he's brought to trial and his fate is determined. That is what we want. But the reason why it has generated a lot of issues is that we know cases that are pending before court that has delayed. I'll give you an instance. In the case of Major Mahama, which is a murder case, which means that it is very grievous and very serious. But we don't see the AG personally involved. But GYAKYE QUAYSON has been charged with forgery and a deceit of public officer, and the AG personally is in court. So it is because of the political undertone or the persons who are involved. That is why we are seeing these things. But I think that we are carrying a very wrong message that if you are not a high-profile person, you will not get justice. If you are not a high-profile person, nobody cares about you. Because I'm involved in Major Mahama as a lawyer. But I think that it has not been on a daily basis. We go every Monday. And if something happens on a particular Monday, it means that the court will not see. So my view is that we are sending a signal to the whole world that if you are an accused person in Ghana and you are not a high-profile person, or whatever crime has been committed and the victim, we don't care about it. But it's because the two political parties are fighting for that seat. And we should not forget the fact that when NDC wins that seat, it is a plus for them. When MPP win that seat, it is a plus for them because of the kind of parliament we have now.
Right.
So at least everybody is fighting to win that seat. But I don't think that when a lawyer comes to court and says that my client is contesting for a seat, so my lord, for this short period, let's say within 1 week, he cannot, so that you have the opportunity to go and campaign. I don't think that the judge should have refused that particular request.
You have that updates, right? You got the updates that the judge refused it.
That is what I heard on another platform when I was coming here. But even for the fact that the initial refusal, the initial refusal when the lawyer was in court, and then he said that, oh, my lord, we are pleading with you because of the by-election, if you could allow for my client to come to court after the 27th. I think it's a reasonable ground that the judge should consider if we are minded to do justice in my respective view.
Let me risk this question. Why do you think the judge refused this plea?
I think it is only the devil
I'm
that
saying
can.
I'm risking the
There
question.
is only the devil that can read the mind of. I think that, in his view, I think that any accused person, Article 19 of the Constitution says that when you are brought before a court, you should be tried within a reasonable time. And you realize that our processes, the court processes, now witnesses do not go to court to go and testify. Their witness statement is put on paper so that they don't waste the time of the court to now the court will now take their evidence. Once you come, you tender it, you are cross-examined and you go. So I think that the judge wants to do justice, but justice must not only be seen to be done, but manifestly be seen to be done. So if the man has come that this is an election, I've invested so much into it, so allow me 1 week to go and contest election. And more importantly, in our peculiar circumstances, the practice of the court, you will not see cases where the judges will say that, look, this case, block your diary. I'm going to conduct this case on a daily basis. I even have cases that have taken dates in December. Some have started taking dates in 2024. So if GYAKYE QUAYSON is given the opportunity to have his case tried within this short period, I think he would have been happy but for the fact that he is contesting an election, and we all know, every reasonable man will know that once you are not there to campaign, you'll be disadvantaged. So I think that is why there's this legal battle in court. And you have also said that there were tantrums in court, or there were, I think that as human beings as we are, but we are trained to be professional. One of the things you are taught in legal advocacy is to have your composure, is to have control over yourself and do your work as a professional. Because the case does not belong to you as the lawyer. You are doing it on behalf of somebody.
Client.
The Attorney General is doing it on behalf of the state. The lawyers for GYAKYE QUAYSON are doing it on behalf of GYAKYE QUAYSON. So it is not your personal case. So you don't put your personal feelings into it, but you conduct it as a professional. And then also, the court is our last resort. The court sits between the boundary of peace and chaos. Because when we have dispute, we return to the court for the court to resolve it for us. So, and then the public are there. So as professional, we are not supposed to be seen to be conducting ourselves in that way. And as other people will say, we are the only learned people, even though we all went to school. So if we are learned, it means that a higher standard is expected of us,
of
you as a lawyer in that circumstances. So I think that it is because of the political interest, that is why this issue of date has generated issues. Because I know instances where criminal cases, even though the law says that you cannot give more than 30 days, we take dates more than 30 days. And if a judge says that I want to try your case within a short period, I think the lawyers and the client will be extremely happy. But the special circumstances of GYAKYE QUAYSON should not be allowed. The question somebody will ask is that, why is it that all this while they were not conducting the case on a day-to-day basis? So,
hold on. Lawyer Nana Obi-Boa has joined me via phone. Lawyer, thank you for your time. Good afternoon to you.
Yeah, it's a pleasure talking to you.
It's a pleasure having you as well. Are you in Accra or you are in Asing North?
I'm in Sinyane.
You are in Sunyani, okay.
Yes.
I'm sure you must have gotten the updates of what happened in court today. That the
What exactly happened?
In terms of the NDC pleading for this case to be heard after the election on the 27th of June 2023, and the courts did not grant this plea. Do you think it's fair on their behalf?
Is it the NDC which is on trial? It is GYAKYE QUAYSON who is on trial. It is not NDC which is on trial.
So let's put it that GYAKYE QUAYSON's lawyers have pleaded that their client is actually, pursuing a national assignment. That's how they put it, a national assignment. And so he be allowed, but that was disallowed in court today.
So greetings to my colleague on the other side. Now, when we go to court and we offer such prayers, it is the discretion of the judge. It is not the discretion of the lawyers. It is not at the discretion of the accused person. It is not at the discretion of the Attorney General. It is not at the discretion of the Defense Counsel. It is the discretion of the judge. And the judge is guided by a lot of principles, a lot of measures, a lot of things in considering such discretion. I beg to differ when people say that some criminal cases cannot be tried on daily basis. I am saying that even civil cases can be tried on daily basis. Criminal cases can be tried on daily basis. Daily basis. I repeat, daily basis. So what is special about GYAKYE QUAYSON's case?
Yes, but sometimes also in the Constitution, it even require or it advises reasonability within the timing of the hearing, not so?
Perfect. 2396. 23, Article 96. Exercising the discretion. But that discretion should be what? Properly exercised. The accused person's lawyer did put up a lot of arguments, submissions. Defense counsel, that is the Attorney General, also responded. The judge was called upon to look at the merits of the case within that given situation. And she exercised that discretion judicially. She exercised that discretion judicially. It is not that she exercised that discretion arbitrarily, judicially. So to that extent, why are we so complaining? And when my colleague said national assignment, well, national assignment means what? We need to be fair. I'm talking about sometimes a good number of us are not comfortable with the way things are going on in this country. If it's a judge sitting at the Western region who upheld the defense of the Jomoro MP, oh, may God praise all the judges. If it is a judge sitting at Cape Coast who upheld the petition of Nyimfa, oh, God should kill all judges. What is happening to us in this country at all?
So with Article 23, you stated, it quotes, administrative bodies and administrative officials shall act fairly and reasonably.
Reasonably. Fairly.
Right.
Reasonably.
Right. And this is...
And administrative acts, judicial acts, customary acts, judicial acts, customary acts, administrative acts. So when a judge says that looking at the situation on the ground, let me feel, no, you know, the problem we have in this country is that if you're unable to finish, if you start a criminal case and you're unable to finish, and the unlikely event that the judge is transferred, you'll be confronted with the opponent case, which is pending before the court now. I believe you are aware of opponent case. Mm-hmm. All of us are in a quandary. All of us, we are in a quandary. Should we continue? Or we should start de novo? So perhaps the judge wants to avoid that scenario. And that explains why the judge says that, look, let's expeditiously determine this matter. What is wrong about that? I mean, I think that our colleagues on the other side, they with all humility, they are interested in playing to the gallery. I'm sorry for my choice of words.
But Nana, I mean, you are both in a competition. And if we consider that competition, it is the reason we're calling it a national assignment, because there's a seat that's vacant in Parliament. And we have to go through a process to put someone on that seat so that people will see development. So
but it is a national assignment.
So it is
indeed.
A national assignment? Yes, that's a national assignment.
Why have you determined that as a national assignment?
Why do you not see it as a national assignment?
The man on the frolic of his own has picked the form, he has filled the form, he wants to contest. And we are saying that it's a national assignment. On the frolic of his own. He has paid the form. He has filled the form. He wants to contest the elections. And you are saying it's a national assignment.
But Nana, you are trying the man in court today because, or the state is trying the man in court today because he may have not given information that was required of him. Of this, we put in quotes national assignment. And you cannot detach the process of this court from what is happening in the constituency in terms of the elections, which is why it's called a national assignment. Because if you think that he on his own decided to pick documents, then it means that the state had no business to do with a man who just picked documents and decided to run for an election, which the state prescribes the processes you should go through with that a particular election. So it is indeed a national assignment.
No, among the charges leveled against him, is that of perjury. When you are arraigned before court, respect of perjury, you'll be tried by the state, whoever, whether it is the police that will be handling the matter or the AG's office. You are being tried. In fact, not long ago in 2023, there has been a recent Supreme Court decision where even intermeddling, the Supreme Court has said that intermeddling into some of us, all of us, a good number of lawyers who were of the impression that intermeddling is just an ordinary civil matter. But 2023, a Supreme Court decision that intermeddling, the process must be mounted. The prosecution must be mounted by the state. Hey, is that so? Intermeddling. So the point now is the state that has arraigned the man before the court with avalanche of charges. I am not interested in the substantive issue. I'm talking about the procedural matters. The man has been charged. The judge, the counsel for the defense raised the point that, give us ample time, accommodate us, we want to do ABC. The defense counsel says, I'm sorry, we need to expedite the trial of this matter. The judge weighed the issues at stake, and the judge concluded by saying that we are going to have daily basis prior. On daily basis. So what is the problem about this? Then we are saying that, the man is a national assignment, then come on, my good brothers in the NDC. Let's help chart a good path for this country. That people will never be in power forever and ever. The NDC also will never be in power forever and ever. Ghana first. Ghana first. Ghana first. Ghana first. So sometimes, with due respect, we should avoid being petty. We should avoid being petty. We should be Ghana first. Look at the situation all of us as a country we find ourselves in the openings case. Is it going to be a retrial? Is it going to be trial de novo? Or what? I mean, so please.
So Nana, let me ask these questions that's been on the minds of many. The issue of Major Mahama, the issue of Ahmed Swale. There's the issue of men's gold where people have lost so much money, some have died and all that. And they are all criminal cases. People are questioning why we didn't see the urgency in running these cases on the day-to-day basis, but for this GYAKYE QUAYSON's case. How do you respond to that?
The position of the law is that each case must be considered on its merit. You never mentioned JB Dankwa's case. Then the MP from Mfansamai. You should have mentioned all these things. Each case must be considered on its own merit. Each case in law, 1 + 1 will never give you 2. Mm-hmm. In mathematics, in chemistry, in physics, 1 + 1 would always give you 2. In law, 1 + 1 will never give you 2. In some cases, 1 + 1 will give you 2. In some cases, 1 + 1 will not give you 2. So please, each case must be considered on its own merit. Each case must be considered on its own merit. Literally considered in Cree as Sambia Pono, I want a Safua. And yes, Safua Bia, Nedi Bia Pono Bia, so camera, and yes, Safua Bia, Nedi Bia Pono Bia. Each case must be considered on its own merit. That is the position of the law.
Nana, yeah, before I let you off, there's also been the worry about some of the campaign lines on the part of the NPP. If you go on the campaign grounds, the messages that, commonly is used against GYAKYE QUAYSON is that, well, he's facing trial in court and will be jailed again or will actually be removed from parliament should he even win the election. So people are criticizing that it's prejudicial comment to be making such, campaign messages when you already know that this case is before the court.
That is not prejudicial. Is GYAKYE QUAYSON facing trial or is not facing trial? Please answer me, my good sister. Is GYAKYE QUAYSON facing trial before a high court in Accra or is not facing a trial before any high court in Ghana? Mm-hmm. He's facing a trial in court.
Right.
Are there charges made against him? Yes. Charges have been made against him. What is the position of the law? The prosecution is required by law to establish her case beyond reasonable doubt. So what happens if at the end of the day, the prosecution succeeds in establishing her case beyond reasonable doubt? There will be conviction. So what follows? Sentence follows conviction. So if somebody says that GYAKYE QUAYSON will go to prison, what is prejudicial about that? What is prejudicial about that? GYAKYE QUAYSON will go to prison. Mark my words. If somebody says this, I mean, what is prejudicial about that? No, come on, please, come on.
So what do you consider prejudicial comments?
Prejudicial comment is a comment made, willfully made, maliciously made, intentionally made, willful calculated to preempt the outcome of a matter.
And comments like these are preempting the outcome of the matter.
No, the person is being factual. The person says that, look, I've read thoroughly the Adamu Sakande's case. I've examined thoroughly the Adamu Sakande's case. I am pretty sure that all things being equal, GYAKYE QUAYSON will be imprisoned. What is prejudicial about this?
Well, you gave a caveat, all things being equal.
Yes. That is where establishing the case beyond reasonable doubt.
Now, I said I was going to. Okay, I said I was going to let you go, but hold on. I have a private legal practitioner in the studio. Well, I'm sorry. I have to call for a break. I'll be back. Nana, please hold on. I'll be back shortly.
Oh, I see.
Yes, hold on. Welcome back to the program. It's Good Afternoon, Ghana. I was wrapping up with Nana Obi-Brian. Nana, are you still there?
Well, I'm there, my good sister. What can I do?
So I'm wrapping up with you before I let you go. You say that those campaign messages are not prejudicial, so they can continue that way.
Oh yes. Imagine somebody says that Adamu Sakande was convicted and jailed during President Mahamad's time. GYAKYE QUAYSON will be convicted and jailed during Nanado's time. What is wrong about that? What is wrong about that? No, I mean, come on. Was Adamu Sakande, was he convicted and jailed during President Mahamad's era? Yes. Was he later pardoned? Yes. GYAKYE QUAYSON, is he facing trial? Yes. And somebody says that, oh, well, from look of things, from the facts, from the witness statements, it can be conclusively be said that GYAKYE QUAYSON, oh, you are saying that this is prejudicial. These are just comments by individuals going around, comments by political activists going around, So please,
Okay.
I don't see how you should allow the politicians to be doing their own things. And lawyers, we also be doing our things. Lawyers, we are supposed to be helping, assisting, facilitating, encouraging the politicians to be mindful of their comments. But certainly when somebody says that, GYAKYE QUAYSON, from look of things, definitely you'll be convicted and jailed. What is prejudicial about that?
Thank you, Nana. We will get back to you. Thank you so much for speaking to us. And I'll get back to you. Nana Obribwahe is a member of the NPP legal team. We'll speak with Alessia Befia pretty shortly. Do you have some responses?
I strongly disagree. Learned colleague, when he said that those statements are not prejudicial. What it is that an accused person, when he's put before court, what are the outcomes? It's either he's convicted or acquitted. But at this stage, he's presumed to be innocent until the prosecution has proved their case. And I also want to believe that the evidence the Attorney General or the state has put before the court has not been subjected to cross-examination. So you cannot say that at this stage it is evidence. I've seen...
Sorry. I have lawyer Segbefia who has joined me also via phone. Lawyer, thank you for your time and you're welcome to Good Afternoon, Ghana. What you faced in court today, how are you going to manage the issue concerning your day-to-day appearance?
Well, first and foremost, good afternoon to all your listeners and possibly viewers. I don't see any problems at the moment because the ruling hasn't been given as to what is going to happen next week. But based on what has happened today, GYAKYE QUAYSON is in a position where he is able to go to Asin North today, campaign tomorrow, and campaign on Friday, because he's been excused from having to be in court for the hearing on Friday or the ruling on Friday. Now, if the ruling goes that he should attend and the next date of hearing is given as, say, Tuesday, which is the day of the election, or Monday, then Monday is not a campaigning day, but it will be unfortunate because that is when you put all your people in place, ensure that people are in place, and then Tuesday is the day of the election. I'm quietly confident that the court, I'm hoping, will rule in favor of the next hearing being on Wednesday or possibly Thursday, so that it will be after the election and everybody will be free to now address their minds to the case. And it's in my humble opinion, in favor of the court to do such. All the arguments that were put forward today by the Attorney General do not run away from the fact that it lies in the discretion of the court. And it's also it was quite clear from the arguments put forward by Chachu Chikata on behalf of GYAKYE QUAYSON that quite clearly we have a situation that the people or the issues that were being discussed in terms of whether or not an election is a public or a national issue, quite clearly it is a national issue. But over and beyond that, if you are allowed or you are aware of somebody who is an innocent person, and this GYAKYE QUAYSON is an innocent person as he stands at the moment, who is contesting an election, he should be given the right also to a fair position to be able to contest fairly. And therefore, even though you're marrying two things, considering the number of cases we have in this country and the number of adjournments we have, a week was never going to make a difference in terms of giving somebody a fair trial. The fair trial law is more in favor of defendants. You look at their position first. And if you have a defendant saying, look, I don't think it's going to be unfair if you adjourn my case further for a few weeks, I don't see it as unfair to me, then I would like to think that the court would take the same position and allow him to have his adjournment to possibly next week, Wednesday or Thursday. So we are quietly confident, but at least he has the next 3 days in which, for the next 5 days, because Saturday and Sunday courts don't sit. So he has the next, today, Thursday, Friday, Saturday, Sunday, to continue contesting. campaigning. Monday is not a campaign day, but it's a day when all parties involved get their people in place and make sure that they check all the logistics are in the right order and place. And then, of course, Tuesday is an election day. And I would be quietly surprised if the court say they will sit on Tuesday when we are actually having the election of GYAKYE QUAYSON, so of the Asin North parliamentary candidate seats. So we are at this moment happy with the outcome as it stands, but we think that also the courts will take it a step further and will grant the further adjournment on Friday to a date beyond Wednesday and Thursday.
Right, my producer is just updating me. I want some clarity on it. I don't know if you have you've received any information on that. That the court will allow GYAKYE QUAYSON to, his case to be heard without him in person or appearing in person until after the election. Is that true? Is that factual? What can you tell us about that?
No, I think that it was until Friday. The hearing on Friday was there's a hearing on Friday for the decision on the motion to be made. And therefore, my understanding is that he does not have to attend on Friday.
The decision on the day-to-day hearing?
Yes, but yes, the decision on the day-to-day hearing will be made on Friday. And he's not required for that decision to be made. So if the court rules that he must be there on Monday or Tuesday as on a day-to-day, then that is the ruling of the court. But they do not require him to be present for that ruling. So as of today, Thursday and Friday, he can still remain in Asin North campaigning, including including Saturday and Sunday. On Monday and Tuesday, depending on the ruling on Friday, we'll see what happens.
Should he not be present in Asin North on the 27th, or the day on which the election is happening? Is that going to affect your...
Well, that is the basis of the application. The basis of the application is that we should go beyond the election. And therefore, we are hoping that the next date that the court will set would be possibly on the Wednesday or the Thursday or the Thursday or the Friday for a hearing, so the hearing to continue. And the whole matter will be adjourned to then. So the whole idea of the hearing is to stop him from appearing in court Monday, Tuesday, possibly even Wednesday. And then the next time he has to appear in court will be Thursday or Friday. And that is what we are hoping to occur.
A quick one, what I was asking lawyer Nano Bibrahin, let me ask you, if the campaign goes against you that GYAKYE QUAYSON is facing a criminal charges in court and therefore is not a good potential material to be an MP in the area, from your information you're gathering from your people on the ground, is that affecting their campaign?
Not at all. I think that there are many factors going in favor of GYAKYE QUAYSON. One, that he had been an MP before, and he was the last MP until the Supreme Court's decision. And the people on the ground were very happy with his performance as an MP. There are issues of the way in which the government has handled his whole issue, which we like to think also gives some level of support to him as a person and as a person who has fought for his people. So from what we are gathering on the ground, GYAKYE QUAYSON is in a very, very good position to win and should win the election, actually. But we are also aware of what the MPP is capable of doing in elections, and so we don't take anything for granted.
Alessa Gbefia, we're grateful for your time this afternoon.
I'm grateful to you. Thank you so much. God bless.
Thank you. God bless you too. So, well, let me come back into the studio. Let's wrap up. So you say that it's wrong conclusion to say that it's not prejudicial.
Yes.
To say that he will be jailed.
Yes.
You know, when I was talking to Alex, he said, we're confident that we will
win.
We'll win the case. That is the day-to-day hearing motion. They will win. Is that okay to make such a comment legally?
I will explain why he came to that conclusion. You know, based on what he has given us, it means that from today up to Friday, the judge will give a ruling on the application on Friday. If the judge gives the application, the ruling on Friday, and Monday is a working day, Tuesday is a working day, but normally a day to the election, 24 hours, you don't campaign. So Monday there will not be campaign. So GYAKYE QUAYSON can come to court. But Tuesday is a civic responsibility for him, even as a voter, for the court to allow him to go and vote. So he's saying that even though the judge has said that the case would have come on today, tomorrow, Friday, now because of this application, he's adjourning to Friday to give a ruling. So he's expecting that based on this, the civic responsibility of GYAKYE QUAYSON to go and vote, the court will allow him on Tuesday to go and vote. Based on that, they are hopeful that by Wednesday after the election, the court will set a date. But if I'm an accused person and the law presumes me to be innocent until a judge comes to the conclusion that I'm guilty, I am not guilty, or unless I plead guilty. So if we are going about to say that GYAKYE QUAYSON will be jailed, and my learned friend says that each case should be treated on its own merit. But when it came to the issue of Abu Sakande, he lumped the two of them together. And I think these two cases are two different cases. They are two. GYAKYE QUAYSON at a point in time renounced. But as for Adamu Sakande, at the time he was even convicted, he had not renounced his nationality. So these are issues that the judge will look at, and the evidence before the court in terms of the Abu Sakande one was proper evidence. But what is before the court now has not been subjected to cross-examination. As a lawyer, I've seen an evidence that leads to everybody will say that, oh, this one. But when it was subjected to cross-examination and other factors, including the application of the law, my client was acquitted and discharged. So at this stage, it will be prejudicial to be saying that, oh, the man will be convicted. It means that you have determined the case already. So that is why I think that I strongly disagree with my learned friend.
Right. We will continue engaging you as the case, goes on in court. That's Theophilus Donko, who is a private legal practitioner. I earlier on spoke with Nano Bribwa, who is a member of the MPP legal team, and also Alexander Sebefia, who is a member of the NDC legal team. My name is Ania Fwampo. Thanks for watching. This has been Good Afternoon Ghana. Entertainment Review is next.